Hello everyone and welcome to the online dispute resolution session for NetHui 2015. Please come in if you're by the door, find a seat. Come in. So, we have some discussion questions up on the collaborative notes document that's linked from the program page if you find us on the Marlborough 1 page of the room. We've got a few people with particular expertise and things to say in this area that we're going to hear from first, and to start off with, we're going to hear from Judge David Harvey. So we'll get into it and then have some discussion later on.
Thank you for that, James. I'm not going to use a microphone. The day that I can't fill a room with my own voice is the day that I stop talking.
The one reason we are using mics is because we're streaming this live, and so.
Okay, so I should have a microphone so that I've got lips rather than lips that move. This is the day that I die. All right, we're here today to talk about online dispute resolution, and I've called it that, although it's a little bit more than that. It's a little bit bigger. But to help with the session, I've got with me Martin Cocker from NetSafe, and he is going to help us out. And I've also got John Duffy from TradeMe. And I might say that it is a great honour to be here, and it is an even greater honour to be introduced by James Ting Edwards. And I say that because he is one of my students who has actually made good. And he's doing the sort of stuff that I'd really like to be doing, but I'm too old. So I just give them the theory, and then he goes away and makes it work. So what I want to talk about is an idea about an online dispute resolution process that goes a little bit beyond the type of TradeMe or eBay internal dispute resolution process and goes right out into the type of civil claim that you might normally bring in a court. I've subtitled this Technology to Improve Access to Justice, because there are some issues in that particular regard in terms of getting into court and paying for it with all of the difficulties that are associated with legal aid. But the other question that I pose is it the way of the future, or is this a bad idea? Do we really want to have a process that is completely online and sort of take the personal appearance aspect out of it? So, what I want to suggest to you is that the present model is a little bit of a problem, because if you look at the economics of it, very little time is spent on dispute avoidance, on the process of, well, why can't we try and stop this thing going any further to court? Why don't we try and avoid having to go along and getting somebody else to make our decisions for us? What about the issue of dispute containment? We're not really sort of trying to keep the issues within a narrow focus. No real effort is spent in that regard. Within the civil jurisdiction of the District Court and the High Court, we have what are called judicial settlement conferences. But that is after the proceedings have gone a long, long way, and after there has been quite a bit of money spent. And then the greatest area for expense is at the bottom of the triangle, where you actually have the dispute resolution. The cost of court proceedings is absolutely phenomenal, not only in terms of bringing your case to court, but also in terms of what happens if you lose. It costs a fortune. So what we're thinking about are different models for a dispute resolution process. Now, there's a mixed model, which we have at present, which is with the Disputes Tribunal, which has electronic filing and in-person hearings, although many of the Disputes Tribunal proceedings can be dealt with and are heard by way of teleconference. So you're sort of getting part of the way there with the Disputes Tribunal, but the Disputes Tribunal jurisdiction is very, very low. And then you have what I call a partial model, which involves electronic filing and hearings, what we call on the papers, where there's actually not an opportunity to be heard in the physical or audio sense. And that's under the dispute resolution service that's operated by Internet NZ and the Domain Name Commissioner for Domain Name Disputes, under the file sharing complaints under the Copyright Act, and furthermore under the Harmful Digital Communications Act, which has just become law. And that anticipates a decision on the papers type of model as well. And then you have what I call the Susskind Model. And I call it the Susskind Model because it has been developed by Richard Susskind, a professor of law and internet technology at Oxford University. And he is the IT advisor to the English Chief Justice. And he has just come out with a plan whereby there is a complete online dispute resolution process to be put in place in England that will deal with civil claims of up to 100,000, I beg your pardon, £50,000, or, depending upon the exchange rate, slightly in excess of $100,000. So what Susskind is proposing, and I'll deal with it in a little bit more detail shortly, is electronic filing and online hearing using audiovisual links, or AVL as we call it. And we have provision under our law for that at the moment in the Courts Remote Participation Act, which allows for audiovisual links and hearings in that way. But the important thing is that we're talking about online resolution of real cases, of the type of thing where you're suing somebody for damage that has been done to your property or breach of contract or something of that nature. And then the final model is the private online dispute resolution process, and I'll just cover off on that for one moment. It's kind of like an arbitration, because the parties have got to agree to submit to this particular process. They've got to agree to be bound. But the process that has been put in place, and there's an organisation in Auckland that's just developing this at the moment, is that there would be time limits for electronic filing of various claims and responses. There would be an exchange of documents, which would be an electronic exchange, of course. There would be mediation, which would be an in-person process. And then following that, there would be a decision on the papers with an outcome within 6 weeks of the process actually starting. And the cost of that, and there is a cost involved, would depend upon the amount of the claim. So that's a private dispute resolution model. But what I'm talking about is a proposal which the court system, the Ministry of Justice, the outfit that I'm with, would be funding and making available. Let's be clear about what we're talking about. We're not talking about forcing everybody into an online dispute resolution model. There will still be a place for traditional courts calling witnesses and all of that sort of stuff. But hopefully we will be able to avoid that in most of the cases, get cases dealt with in a short period of time, and save everybody a whole heap of money. Now, before the case actually gets to a hearing, quite early on, we want to have some kind of mediation process where the parties can get together and try and sort out exactly what it is. I'll give you an example of why mediation is important, and this one comes from the United States. There was a person who was a patient at a hospital, and things went wrong. And they were very dissatisfied with this, so they went and saw a lawyer and said, you know, what can we do about this? And the lawyer said, sue, of course, which is what lawyers do. And so they did. And the hospital, of course, wanted to avoid liability and wanted to contest the matter, and they had deep pockets, and their insurers were behind us and so, behind them and so on. And so they fought it every step of the way, and it ultimately went to court, and the complainant, the plaintiff in this case, got an award of millions of dollars. And the lawyer said, that must be really great, you must feel wonderful about that. And the patient, complainant, said, well, no, all I wanted was an apology. So when you have a mediation process, the question that you want to ask, and perhaps the mediator caucuses with the parties, is, well, what do you really want out of this? Because it may well be that it's something that the other side can give, and you get a win-win outcome, which of course is something that is really good. Furthermore, you have a process that is under the control of the parties, so they own the decision. So you put your focus upon this mediation process, and there's a mediation process for the domain name dispute resolution system, for the disputes tribunal. It's proposed in the Harmful Digital Communications Act because before proceedings hit the court, they've got to go to the approved agency, and the approved agency attempts to mediate an outcome for the parties. And the Susskind Model also has the mediation process. So why are we looking at online dispute resolution instead of the court process? Well, we've got the technology. We have the technology with us right now. It's all there, it's in place. It's not a problem. Second thing is, it's cheaper to use the technology. Now, there are occasions when this can cause a bit of a problem. I was involved in a case a little while ago where I was told that the case actually had to go ahead. Has to go ahead, Judge. We've got a witness from Canada who's flown in to give evidence. I said, what? You know, why aren't we using the Technology Act here, the Remote Participation Act? They said, oh, well, it's too expensive. And I said, do you mean to tell me that it is more expensive to have an AVL link to Canada than to fly the witness in from Canada and put them up for a couple of days and then fly them back? Yes, that's right. Well, how can that be? Well, the system that the courts use is a dedicated system. It is very expensive. I said, why don't they use Skype or Microsoft Link or something like that? Oh, security. I said, come on, this stuff is encrypted. What is the problem here? So anyway, the witness was there from Canada. We heard the case. So let's get serious about this. The technology is available. Don't give me problems about security when you've got an encrypted system, for crying out loud. And don't think you can flim-flam me, because I'm not flim-flammable on this. Then, of course, you've got time and distance considerations. So I think the example that I've given you from Canada is a classic example. It's easy to use. It is not a problem. You can use the technology, you just a couple of mouse clicks and you're in. And of course, and this isn't going to please the lawyers, and I know there are some in this audience, there's a reduced need for lawyers and they're not going to be able to charge as much. So when we look at the Susskind model, instead of having the normal sort of triangle, we have an inverted triangle. So let's put all of our resources into disputes avoidance. Let's put all of our resources into online evaluation. Let's give plenty of information to the parties. Let them know what is going on. And if that doesn't work, then let's try for containing the dispute. Have some kind of inquisitorial process with an intermediary who will say to the parties, is this what you really, really want? And there's online facilitation, a process by which all of this can take place. And then at the very end of it, at the bottom of the triangle, the bottom of the inverted triangle, yeah, let it go to a dispute resolution, but let's have specialist
the latter, so the better, the Susskind kind of model. But then it sort of hourglasses back out because you have, a lot of dispute resolution at industry level and amongst users, and using the tools that are available. Then that fails. The people can turn to the approved agency, and it has quite a fast ability to try to contain and resolve. And then if that fails, it then drops into the district court, and we all have our different views on the district court. But what is true about it is that that would be a relatively expensive process at the moment. And so our interest is in how you could streamline the process to actually achieve that sort of ladder triangle. So I can explain processes around the HDC if people want, if people have questions about that, but I won't, in case people all know how it works and I'm just patronising people. Over to you, John.
Yeah, well, I guess from my perspective, so I work in the team at TradeMe that resolves, that works on most of our disputes between members, and we resolve around about 70% of the incoming complaints we receive, and this is trader to trader type disputes or trader to run-of-the-mill consumer. So effectively, we don't call it an online dispute resolution mechanism, but effectively we're running one that seems to work for the most part. So, and thinking about what I was going to talk about in this session, I was really reflecting on what the aspects of our model are that make it work. And there are some things we can take out of it, but I'm probably the first one to put my hand up and say we work within our own community. It's governed by contract, and it has aspects that you potentially could not replicate out into the broader community, unless you got some people to sign up to social terms and conditions or something like that. But we are kind of judge, jury, and executioner in the process, all in one go. So it's a quick, dirty system that allows our specialist investigators to hear the parties out, look at their history within the TradeMe environment, work out, I guess on the balance of probabilities, where fault lies, and then put pressure on the person who's done the wrongdoing to put it right. And that's kind of flies in the face of natural justice a wee bit, because we're using, a whole lot of stuff that they've done in their past interactions with us on the website to inform our decision-making process. But the good aspect of that is it means we can be flexible, we can turn on a dime, and we can tailor our approach to resolving the dispute to the dispute itself as it exists in that point of time. So that's a little bit provocative, but they're starting points for a discussion. So I'll chip in when I've got value add over and above that.
Okay, so I'll just outline. We've heard potential model for the courts from Judge Harvey. We've heard from Martin on his specific topic of concern, and we've heard from John about some of how TradeMe approaches things. And I think we have a question over there.
Okay, so I have sort of almost a two-part question, because a lot of online interfaces generally go through consumers, and so or just people who are using services or online message boards or comment boards when there is a dispute. Quite often, because there are custom rules being put in place for the mods or the admins to try and manage and resolve these disputes, what protections would you see put in place to prevent against sort of an online trolling via providing fraudulent reporting or fraudulent claims for disputes? So I'll probably better off use an example for this one. Facebook quite often has a requirement that you use your own identity. When my husband was teaching, a lot of his students got a hold of his Facebook account and would continuously report that it wasn't his real name. And so he constantly his account kept on getting removed, kept on getting deleted, kept on being... and even if he provided his own birth certificate, which is sort of what they would require to reinstate it, he just ended up just having to start from scratch, create false names just so that people wouldn't be able to track him down, and then just continuously end up in this endless loop. And that was primarily because, as an educator, you'd then get seen as a target for some trolling. But this happens quite often, and that regularly with, say, commercial sites with, say, media sites where you'd have news being reported.
So I think there's a couple of interesting issues in there, and anyone is welcome to request a mic and come in on that. But I think it might be interesting to hear from John on what TradeMe does to address this, and perhaps from Martin on the principal issue, like how can this identity verification thing be addressed. So I'm gonna pass the mic to John first and hope he's willing to take that.
Yeah, no worries. It sounds like a tricky situation. What's Facebook done in these circumstances? Have they looked into the people who are making the allegedly false reports?
So as companies do, they just generally take the approach that it's safer just to not investigate and ensure that. So it is safer just to not do the investigation and then just close off the account or delete account. So there's no protection in place against trolling or false reports. So that sort of idea is quite often the case, that you could have people who are sort of doing the opposite. Instead of being open and addressing someone directly with an argument or verbally face them, what is easier is just to make a false claim or a false report, and you can attack them that way because they're getting the services removed, they're getting things cut out, and that sort of thing.
So in my mind, the website has a definite role to play in that. If you are providing the platform for interaction, unfortunately that comes with responsibilities, so they would, in my mind, they would need to be more involved. And if your husband has legitimate claims and he can point at memberships that are trolling him, they should be looking into that and taking action if it's practical. Sometimes it's not practical, let's be realistic. Sometimes claimants make false claims, but you can't put your hands up and just say, we're a platform, we're not going to do anything about it. We've certainly tried that in the past, and it's not sustainable. You need to get involved, but the degree to which you get involved has to be tailored to the dispute. That would be my take on it. So it's a cliche, but we do it on a case-by-case basis. So we've got a reporting mechanism if someone places, let's use feedback as an example, as everyone's familiar with TradeMe feedback. If you get feedback that you dispute, there's a process that you can go through to dispute that. If the other party refuses to remove it, then a TradeMe staff member will become involved, and if it's, let's say it's something that might tip the scales under the HTC, we've got staff there who will look at that feedback and remove it if it's of a questionable nature. There is, of course, feedback that will annoy the other party but is completely legitimate, so you need to have somebody looking at it. The computers can't do that for you.
So TradeMe is an interesting example because I think, and you can nod or shake your head if I get this terribly wrong, that people have an economic interest in the reputation that goes with their account, right? It's more attractive to buy from sellers who have a strong reputation based on their positive feedback count. And so TradeMe is quite suited. But one of the things we might want to explore in discussion is what sorts of disputes fit that model and have that thing going for them, and which ones it's more difficult to handle in this online kind of way. Judge Harvey's outlined a really nice use case. What are the limits of this use case?
So I just pick up on, obviously in NetSafe's work we see a lot of the use of anti-bullying tools to bully people. So that's essentially what you've got there, where you've got somebody reporting abuse, constantly as a way of abusing people, and the responsibility lies on the providers of that service to work out how they counter the use of their tools in that way. And it surprises me to hear that kind of feedback about Facebook, because they are quite proactive in trying to improve their services. I suspect that if that's something that happens often, that is something that they'll fix. I guess the bigger question, not bigger question, the sort of bringing it back to that kind of Susskind proposal is, okay, we see a lot of abuse of online tools, a lot of people who have good technical ability produce evidence that is false, etc. How do you counter that in the model that the judge is referring to? So perhaps he's got some thoughts on that. Sorry, people.
Okay, just to sort of pick up on that point. The first thing that I think I should say, and your example of the Facebook case is a good one, and what John and Martin have said is particularly interesting. These are cases that involve aspects of what you could call reputational harm. Within the online space, your reputation can be damaged very, very quickly and very, very badly. But what remedy do you have? I mean, if it hasn't hit the serious emotional distress threshold for harm under the HDC, there's not a lot you can do apart from bring a proceeding for defamation, which costs the earth. So to have these alternative dispute resolution processes in place where they can be examined, and they should have been in the Facebook case, is really, really great, because it means that people are getting an outcome and they're getting a resolution of a dispute. And that is just fine. And now I've forgotten the second part of...
abuse of the system.
Oh, look, well, sure. Every system is open to abuse. Without going into too much detail, the HDC Act does have some provisions that mean that the likelihood of the system being abused is mitigated to a certain degree with the utilisation of the approved agency and various other tools that are available. So, and then once it gets to judicial level, a clearly vexatious complaint can be biffed. So, but I don't want to talk about the HDC too much, because I think there are much wider issues about online dispute resolution.
So I think we had a question just over here.
I just wondered, with shifting things to encourage mediation early on, I know one of my experiences recently was with the tenancy dispute mediation service, and it occurred to me that quite often, if you have a dispute, you have an equal power balance between the two parties, and I wondered what kind of things you put in place to make sure that if people were going through mediation where they could be more persuaded one way or the other, what you could put in place at that level to protect people from those power imbalances.
Yeah, okay, power imbalances in many respects are matters of perception, and a properly trained mediator is going to deal with that and going to put everybody onto an equal footing. I think it's an essential part of the mediation process that everybody has an equal say and has equal voice and equal, if I can use the word, power within that particular process. If it's a properly conducted mediation, that's what will happen. Now, I'm not saying the Tenancy Tribunal Mediation Service doesn't do that, and I know that, it can be pretty intimidating where you have people who've got heaps of experience within the mediation process and can articulate and all the rest of the rubbish. But, that's what happens in court proceedings as well, and you can, if you handle it properly, it can be worked out so that imbalance doesn't happen, or at least it's kept to the lowest possible level that you can hit. It's called a fair trial.
I guess as well, online might be a way of evening that out a bit, because it's potentially a less intimidating thing to have a say when you're sort of writing it, or
it's a lot less confrontational.
We had a question here.
Cheers. I was just going to make a comment, really. One way of preventing improper claims, vexatious claims, and it may be an unpopular solution, but it works, is filing fees. Now, I should mention I'm a lawyer, so I've been on the receiving end of this and on the other side, although most of the work that I do is defence work for commercial companies, technology companies, and so on. And what's happened recently is there's been a big rise in what's known as lay litigants, in other words, people who act for themselves. In the court system, in the disputes tribunal, you can't be represented by a lawyer anyway, so you have to act by yourself. But in the court system, you're getting a lot more lay litigants come in, and the Chief High Court judge and various other people in the judiciary have commented that this is causing difficulties for the system, because cases often aren't conducted in the same efficient, or you may use a different description of it, as if lawyers are involved, and if there's, in particular, if there's some sort of monetary constraint by the client on what's happening in the court process. And we've seen a lot of cases where the courts have waived fees because you want access to justice, and you don't want a court fee, filing fee or something like that, to stand in the way of someone getting their day in court. And that's all good. The downside is that it allows a lot more vexatious type complaints. Now, obviously, one person's vexatious complaint is another person's completely legitimate grievance. But just from the statistics, we can see that there has been a significant increase in this. And so certainly in terms of things like people abusing a system by filing false complaints or making raising false disputes, one potential solution is a filing fee. Even a relatively nominal one like $5 or $10 might stop the kind of school kids jumping in and making a whole bunch of invalid complaints. So that's just one possible way to address part of that.
There are no filing fees payable for complaints under the Harmful Digital Communications Act. And that's made abundantly clear. That's specified in the legislation. But by the same token, the availability of the approved agency as a filtering process means that those types of complaints will probably be dealt with. Now, that's within that particular piece of legislation, and I agree with Guy that there are some difficulties in terms of vexatious proceedings. But I'd prefer that somebody had their day in court, frankly. And believe me, I've seen a few cases that are, well, yeah, okay. But sometimes they've got something in them. And I think it's more important that there be a right to be heard. But hey, I'm one of these weirdo Democrats, so yeah.
Hi, Ross here. I have two questions, one for Judge Harvey and one for John. Judge Harvey, in your view, do you think access to justice is an issue in New Zealand? And if so, how well do we understand that problem? Because I think the technology is a bit of a solution to that, but it obviously presupposes we understand the extent in which people can resolve civil claims and things. And the second question for John was, do you operate a precedent-based system, or is your online dispute totally case by case?
Okay, the access to justice system, it was mentioned just a little while ago by Guy, I think, that the Chief High Court Judge Justice Winkleman expressed some concerns about in-person litigants. And that has a lot to do with access to justice, because the obligation of the state is to provide a dispute resolution process for citizens. And that is particularly so in any organisation or any country that places any sort of value on the rule of law, which we do. So to make it difficult for citizens to come to court is anathema to that particular proposition. Strong word, but it's true. Part of the problem has been, A, the increasing costs of bringing proceedings, not only in terms of filing proceedings in court and getting the show on the road, but in terms of paying the people that you need to pay to get the job done. Coupled with that, and this is not only a problem here in New Zealand, but it is in England as well, severe swinging cutbacks on legal aid that are making it difficult for the people who aren't impoverished, but furthermore don't have the bank balances to fund legal proceedings. And that, to me, is very, very problematical. And you can't really sort of say, to no man will we deny justice, as was said, I think, Chapter 39 of Magna Carta. You can't really do that on a cost basis, on a cost economics basis. If you're going to have a justice system, it's got to be available.
Short answer is no. And there's no Magna Carta quote to back that up either. You might be surprised to hear. We've got operating principles that we apply to every case, but frankly, behaviour, technology moves quickly. We need to be flexible, and if we're bound by something we did 15 years ago, then, and I wouldn't be that extreme, but we would be less flexible to move quickly to resolve it. And I think it goes back to the model that Judge Harvey put up. We put a lot of effort in that pre-dispute phase. It's actually a bad outcome for us if two of our members end up going to the disputes tribunal or the district court if it's something extremely serious, or police if it's a fraud matter. That's a really bad result, because that process is flawed, and it's a pretty poor user experience on our website, so we don't want to get them there, and to be bound by precedent would slow our ability to react down, I think. Not that we don't learn, and we don't learn from our mistakes, and we make them.
Cool. Sorry, and we've got another question over here.
Thanks. Joy Liddycote from the Privacy Commissioner's Office. A couple of questions. I mean, this is really interesting for us. I think it's going to be interesting for us to do perhaps some analysis of our complaints. So what I'm about to say, I'm just sharing anecdotally. But certainly one thing that we often see is that people will come to our office with complaints about a wider dispute that's been happening, perhaps with an online provider, and seeking access to information, making a personal information access request under the Privacy Act in order to help them resolve that dispute. And it's an issue that we see a lot of, is the providers then getting into trouble with actually tracking and making sure they've got good documentation of the interactions they've had with their customers, and then sort of reflecting them back. And I just wonder if that's something you might want to comment on. What sort of systems do you have to make sure, or advice do you have to people to make sure they do have good systems for getting access to that sort of personal information quickly and easily? And I suppose the other sort of question that we often see also is people get lost sometimes in the online dispute resolution process. A series of emails going back and forth, getting longer and longer, becoming quite confused, the wrong person in an organisation trying to respond to a customer instead of escalating it, and things like that. And so people coming to our office with disputes about a dispute. And so, again, I just wonder if you've got any thoughts about that in terms of thinking about, good practice in online dispute resolution.
Yep, good notes are everything. So we've, you never know when you're going to be hauled before the OPC, but we've built a bespoke case management system to manage our interactions with parties to a dispute. So we've been running that for coming up to 2 years, or 18 months to 2 years now. So it's key. You never know when it's going to end up being evidence, either in a civil or a criminal trial. So we need to do that out of necessity.
Yeah, the issue about the dispute is always problematical. And as far as my understanding of Richard's model is concerned, I have spoken with him about this, is that the day-to-day, the technical aspects, the sort of what sort of paperwork or systems are you going to run, hasn't been worked out. Richard Suskind's a very big picture guy. So when it comes to working out the detail, other people go away and do that. My vision of an online dispute resolution process are web-based documents that make things very, very easy to fill in, so that you can state what it is and what the problem is and so on and so forth. And I envisage that the rules relating to complaints under the Harmful Digital Communications Act for civil enforcement orders will similarly be set up, because we got to have e-filing for this sort of thing. So let's make it as easy as possible, and so that the thing doesn't become like a Russian doll, where right in the middle is a substantive issue and then there's this whole lot of stuff around it. I'm conscious of that, and we want to try and make it as simple as we possibly can. A claim, a counter notice, maybe some kind of answer to that, end of story, and on it goes. So, yeah, it's still sort of in the thinking process, but really, the idea of using the technology and using it creatively to provide good societal outcomes, I think has got to be something that we consider. And I know that there are arguments against an online dispute resolution process, and there are arguments for the opportunity to deal with people face to face because of the dissociative effects of the technology and so on. But maybe we got to get past that. We're entering a new paradigm and we need to change our thinking. But anyway, are there any other questions? We've got plenty of time, heaps.
So I just pick up on that point before we pick up the question. Joy, one of the things we did a little bit of analysis. When people come to NetSafe in an online dispute at the moment, they describe that dispute to us. They say, oh, you know, this person did this thing. Is that an offence? And we say no. And they say, oh, this person did this thing. Is that not an offence? We say no. And eventually they say, oh, you know, it's breached my privacy. And we say, oh, bingo, you know, because there's a process and there's a set of principles and stuff. And I think that as a result of that, the clarity of the Privacy Office's processes and, you know, ability to define an offence and the accessibility of that is becoming like a magnet for other things online. It will be very interesting to see how, if HDC can sort of pull away some of those that really weren't privacy, but that was the only thing people could, you know, grab hold of.
There were some questions.
Yes, more questions. Yeah.
I'm sorry, I've completely forgotten the technical term for this, but it's something like venue shopping, and it's forum shopping. Thank you, and it's what's basically killed the effectiveness of ICANN's UDRP is the fact that some UDRP arbitrators basically advertise that they will always rule for the plaintiff, and not in quite so many words, but close enough, and as a result, they get all the business.
Not everybody's UDRP.
Universal Dispute Resolution Process.
Thanks.
It's how .coms get nicked from people who've had their blogs on them for 10 years by companies that have been formed 2 years ago with the same name. But anyway, let's just ignore that. So you've got something like the Susskind Model, and okay, so you have the parties go into this and they go through these steps, and that's all well and good, but is this going to be a mandatory replacement for the existing methodology? This is going to be somehow an opt-in thing. And if it's an opt-in thing, how do we make sure that the mismatch of power doesn't cause the people like the Facebooks of this world to insist that you're going to their particular Susskind Model site in East Texas, another forum shopping destination, by the way, for patents this time, and so they always, every time, win. I mean, there's got to be some way that this can be managed so that doesn't happen.
Yeah, so I'd expand on that. I'm going to throw this to Judge David Harvey after making it more difficult. One is, does it have to be opt-in? Do you get to choose your forum? But also, generally, what would give something like this legitimacy?
Okay. First thing, the Susskind Model is for claims of in England, is for claims of up to £50,000 or $100,000, which is significantly higher than the disputes tribunal is at the moment. Okay, so let's say that you've got a claim of $90,000. The starting point, the default position, is that you'd go to an online dispute resolution process, this process. Okay, so anything higher than that, you're probably going to use the conventional process. I would imagine that in any ODR system, you would have an opportunity for a discretionary decision to go to what you might call the conventional process, the non-online process. So you're not going to cut it out altogether, but certainly this would be the default position for any claims up to a particular level. Now, 100 grand's a lot of money in New Zealand, but by the same token, I don't think that it's unreasonable. Second thing, legitimacy. When you talk about Facebook nominating East Texas, that's fine, because you sign up to a terms and conditions type of deal which nominates an arbitration process, which says that the governing law of the contract will be the law of Washington, and the courts that will deal with it will be located in Seattle. You sign up to that, that's a contract. That's a contractually based dispute resolution process. This is one that would be run by the government. This is part of the proper courts process that is available to all citizens, and that is backed by the government. And all of the rule of law, natural justice, judicial oath principles, and so on and so forth that would apply. I'm appalled to hear that there is a suggestion that any person exercising a judicial power might say, I'm going to rule for the plaintiff. Yeah, okay. Okay, Bruce, I'll take about a ton of salt with that, but well, yeah, I can understand that. Yes, Ian.
Can I just get confirmation that there's no problem about writing into, say, a software development contract that if there is a dispute, it'll go through this procedure or that procedure? Is there any technical problem, legal problem?
No, none at all.
So why doesn't it happen?
Well, most software contracts that I've signed up to, and I've signed up to a few, have what's called an EULA, which of course as a lawyer I diligently read every single word, as does everybody else who signs a contract. Yeah, sure, right. How many actually do read EULAs? Okay, right, fine. Yeah, okay. Yeah, but you see, the thing is that your terms and conditions will set up a dispute resolution process, and when you click the I agree, you agree, and that's it. You're into it. You know, they've got pretty bad legal advice if they're not trying to give themselves a home court advantage.
I think there's a question at the back of the room.
Mine was actually very similar. It's to do with how do you get people into an online dispute resolution? Because if we're not talking about making this mandatory, then presumably both parties have to be able and willing to discuss this online. And I would imagine that in most cases, at least one of them isn't, because they've got an advantage in saying, no, we're not going to do this the quick way, the easy way, the cheap way. We're going to drag this out as long as possible and expensive as possible so that you're less likely to go ahead and do it. And so you're sort of stuck in a position where you're either saying, no, you have to do this online, or we're saying either one of you can just say, no, I don't want to do this. When we talk about Trade Me or Facebook, they can say, right, you don't want to engage online, you lose, bye.
This process is a court.
So,
okay, it's a court. And the law says any claim under $100,000 is going to go before ODR. Okay, that's the default position. If you want to opt out, then you're going to have to persuade a judge that there's a case for opting out. Either that the case is unsuitable for ODR or it's too complex or something of that. But
or
the
that
default...
I'm 80 and I don't know how to use anything online, or... You know, if you're talking about general online...
Actually, seniors are the greatest Twitter users, of which I'm one.
Yes, I mean, there certainly are, but there are also a lot of people that, for whatever reason, age, mental capacity, rural...
You do have a problem with the digital divide, and in that case, you can seek assistance. If you don't have a computer, I have a dream, okay, and it's this, that in every mall in New Zealand, there will be a terminal that will allow people to access legal information and take care of their legal affairs for free. Okay? So that gets around that part of the problem. They're already available in libraries, so there's no difficulty there. Using the computer, get somebody who can help. Get in touch with your kids, or if you're 80, your grandkids, or your great-grandkids. They'll know. They'll probably be able to do it for you on their smartphones. Okay, but it would be mandatory in the first instance. Yeah. There wouldn't be, you know, this whole bogey of forum shopping and all of the rest of it. It doesn't happen.
Sorry, quick question. Is anyone in government listening?
Yes.
Now,
Claire Curran was here a little while. I know she's not in government, but you never know. There is interest in this, and certainly it's been something that has attracted the attention of my Chief Judge.
John Elwood, just wondering, in this process, are the decisions that the judges make going to be appealable in the traditional way? And the remedies that they can grant, is it only financial or is it all equitable remedies?
Across the board. Yeah. It's a court that is conducted online. Yeah.
There have been some moves in this direction, you know, for a number of years. I mean, Justice have been investigating e-filing for quite a while, and it seems to have failed, and then it seems to have failed also in the UK. I'm interested in what your views are on why the judiciary or the judicial establishment has been so slow to move towards more technology-based disputes resolution.
Okay, right. First thing, it's not the judiciary. Okay, we are ready, willing, and able to. Technology is better. Here we go. We're ready, willing, and able. We're ready, willing, and able to go the technological way. I imagine that, and I only imagine it, this is another dream, that filings under the Harmful Digital Communications Act will be electronic. All you need to do is have a clause in the rules which say that filing may be electronic, and it's there. There is already de facto electronic filing as far as some family court proceedings are concerned. There are wide discretions in the rules for the courts to regulate their own process. Well, it is happening, but it's happening slowly. And it's often happening with a certain degree of invisibility, because I don't know if you've had anything to do with family court proceedings. I would hope not. So you might not be aware of the fact that it happens that way. From a default position, I get lawyers who are sending their documents in by way of email, and they come into the court and then they just forward them on to me, and that's a very, very convenient process. So you've got sort of e-filing by default, even although it's not officially authorised by the rules. I could talk a lot about the electronic bench and electronic filing and so on and so forth. I don't think it would be proper for me to do so in this forum. What I'm trying to do is look a little bit ahead and go a little bit further.
Yes, the question I'm trying to drive is, what are the impediments to this that you see? Why isn't it happening now? Because the technology exists.
Yeah, the technology is there. There are a whole lot of things that need to happen. There's got to be a political will for it in the first place. And generally there's got to be some kind of indication or recognition of a problem. That's the usual sort of thinking that you get on something like this. Whereas the way that I see it is, if you build it, they will come. And why don't we just do it? Because it's a fairly low-cost approach to a very high-cost position that we are in at the moment.
So that's the general position. We're in the last 5 minutes or so of the session, and one thing I'm wondering about in all these sessions is, are there any voices we haven't yet heard from in here that we'd like to? Now, we haven't heard from that many women, though there are a number in the room, and we've got a number of things in place to make it easy for people who wouldn't otherwise be heard to do so. So make eye contact with me or Ben or Maria, and we'll enable that. We'll get a mic. And otherwise, we'll give that a moment to happen.
We've got a question.
Okay.
Can you turn the mic on, please? That better? Okay. Martin Keeley here. Judge Harvey, I wondered if you might comment on involvement of third parties like witnesses in this type of online structure. I think particularly initially of you send your subpoena for a witness and you're supposed to turn up at the Ottawa Supreme Court AB Centre and it says when, and it's Tuesday at 2 a.m, thank you. And beyond that.
Okay, pre-recorded evidence.
Okay.
Pre-recorded statements, we have provision for that under the rules now, Section 103 of the Evidence Act. So that's not so much of a problem. You could have witness statements submitted by consent with a leave to cross-examine if cross-examination is desired. So the issue of getting evidence on a claim is not so much of a problem, Martin. There's an awful lot of facility available under the current law to do that. Does that help?
Particularly wondering around the technical interception of the communication.
Skype and Microsoft Link are encrypted.
There's a question.
And in any event, courts should be open.
I guess my question was when would lawyers get involved, and how much of this dispute resolution can you do without lawyers and the dispute avoidance and?
Probably about here.
Yeah.
Okay. Hopefully they wouldn't be involved.
Yeah.
Up there. That would be something between the parties.
So
okay.
Just reducing the role of, I guess, of lawyers and the costs involved with.
Yep.
Yeah.
Lawyers are going to hate me for it. But Susskind has written about tomorrow's lawyers and the commodification of legal services. So there's no reason why we shouldn't be looking at it in view of dispute resolution as well.
Obviously, processes, legal processes, can be quite intimidating for women. And I'm wondering, I'd be interested to hear of other women in the room about their thoughts about this process, because it feels to me like this seems like a safer environment. So I'm interested to hear thoughts from that.
Hi, my name's Leanne and I'm a policy lawyer from Australia. I know some of the courts in Australia have started to integrate some practices that are part of this process, particularly to deal with issues like women who are victims of domestic violence or in sexual abuse cases. So, for example, being able to give evidence via Skype off-site so they don't necessarily have to be in the same room. Sometimes it's actually even in the same building. In the court where I worked, there was actually a separate space. They went in a different door, so they were in the same court building, but there wasn't that interaction, and technology facilitated them giving evidence. There's a few courts now in Australia. If you just Google Skype Court Australia, you'll see that they're trialling to deal with the issues around access of justice, of people being able to give evidence, via Skype from a local, rural police station or council office or some sort of building like that into the more centralised courtroom in the capital city. So I think there's definitely ways where technology, particularly around witnesses, can facilitate access to justice.
Just to pick very quickly up on your point. First thing is, this is for civil processes. This isn't for criminal. I don't see it as operating within the family violence space. I don't know if it's appropriate for family law at the moment, and I haven't thought of that. As far as the other issue is concerned, I've just come out of a trial where we had a couple of vulnerable witnesses. Their evidence was pre-recorded and played to the jury by way of DVD. They were located in, like Leanne has said, in a remote room where they weren't actually in the courtroom, exposed to the 12 people on the jury plus the lawyers and the gowns and all the rest of the crap. And they were cross-examined and questioned in that particular way in a non-threatening environment. So we do have the processes that mitigate as much as we possibly can in what is referred to as an adversarial system, that type of problem. There are steps being investigated by the Law Commission to look at resolving problems within the sexual violence, domestic violence space in criminal law processes. But I would say that any changes there are a long way away.
Okay, so I think that brings our session to a close. Thank you everyone who joined in and participated. There's the opportunity to, of course, grab anyone and have a conversation in between other sessions. And if you've got something you're particularly interested in, turn it into a bar camp session. That's over to you. Thank you very much.